Hello, this is CF Lieu from howtofinancemoney.com. Today's topic is about wills and trusts. And I know this is a boring topic for most, but if you are near the retirement or when you're at age 50 or 60, you would be really thinking about this. Now, the reason I did this is because I do not think I've covered anything about wills and trusts before, part of estate planning as my blog content. So never before, but it's an irony because I do provide services in this area, estate planning. Now the second thing is because there's some probably very senior readers of mine who have been asking questions about wills and trusts, about estate planning in general. So today I'm going to share with you some of the things. In the next few episodes, I will be sharing things about estate planning. Now, today we are going to cover mostly about wills. Now, the thing that I'm going to cover are the things, the very basic thing that one should know to the very advanced or practical thing that is in practice when it comes to estate planning. Practical. Now, you might have Googled some of those things in Google, but there are things that are practical in our position as a practitioner that we can tell you to take care of and to be aware of. Now, wills and trusts, I've shared with you one of the basic things and some of the stories of common people, but uncommon stories. Now, the very easy or very straightforward way to define wills is a wealth distribution tool. So, and one dies, you have a will, so you distribute according to your will. Now the thing is, a lot of people say I do not need any wills. They say in Hokkien, they say bo chap xiao, I don't care, right? I don't care. What is the I? You got iPhone, iPod, ITV, things like that. But for a lot of people, they say I don't care because I don't have much assets. Now that is the wrong concept, because whether you like it or not, if you do not have a will, by law, you have already written a will. Now, the reason I say that is because according to the Distribution Act, right, everyone has already written a will, and the distribution is based on this schedule. According to the law, you don't have a will, the law will take effect. This is what you have. So, in summary, according to this schedule, the direct party that will benefit from any asset, or they call it estate, right, after someone dies, is your spouse, children, and your parents. Now, because the law always puts the children or the minor priority first, what is known as issue in law term. Now, the thing is, if someone dies, example, if your spouse, of course, if you have no parents or no children, everything go to your spouse. But if you have a spouse and your children, but no parents, then your spouse will get 1/3 of the asset, whereby your children will get 2/3 of your asset. Now, in the case that where you have surviving parents, spouse, and children, your children will get half of your asset, no question on that. Whereas your parents and your spouse will share 1/4, quarter and a quarter of your asset. Okay, this is the law, right? So, don't have a will, you have already written a will, and it's already written for you by the law, Distribution Act. And the next thing is a question that I always ask my client: how often you don't travel together as a family during vacation? Like, how often you don't travel together? Now, mostly when they come to family vacation, you do travel together, right? Now, the thing is, what if tragedies happen? Okay, we see a lot of cases in Genting and stuff whereby the parents actually unfortunately dies in an event, and who takes care of the children, right? Who takes care? If you don't have a will, who takes care? Because if you still have a surviving spouse, your spouse of course will be the guardian of the children. But if both parents are not around, who takes care of the children, right? And then if things like this happen, you don't have a will where you can actually state, okay, we can state who will be your guardian. Now, of course, you need to inform the guardian that you appoint now, right? So, who are your guardian of your children? Now, the thing, this is a very complicated thing, because if you don't have a will, then the court will actually grant, okay, which in their opinion is the best one, people to take care of your children. Okay, Okay, so it might not be of your choice, of your choosing. Anyone that claims that, okay, you want to take care of my children, the court will assign whoever makes sense to the court, right? So in a sense that you under children, who will be the guardian? So you don't have a choice. Now, if you both your parents pass away, it's up to the court to decide. And I don't think that is the thing that you want. Now the next is about the EPF nomination. Okay, if you have not do your EPF nomination, then do it now. Now, EPF nomination, normally you nominate anyone. And the powerful about EPF nomination is that it's not governed by Distribution Act, the wills. So, because EPF have their own law, so any money cut into EPF, if the EPF member die, it will directly go to whoever he or she nominates. Now, a wills will not able to override EPF nomination. Now the thing is, what if, like in the previous case where you nominate a spouse, now the spouse also dies in an unfortunate accident, so the EPF nomination fail. So how, right? So we need to cover that. See, the thing is, because if EPF, now if a nominee is, if you nominate children, of course go to the spouse, but the spouse no longer here, then goes to the children. Now the thing is, if your nominee, in this case your substitute nominee or children, is a minor, less than 18 years old, now the thing is, this money will be parked under Amanah Raya, held by a public trustee. So it will park this money until your children reaches 18. Now perhaps this is not what you want, so the other option is to write a will to avoid this kind of complication. Now the next thing is that a lot of people will ask that, hey, can I write a will on myself without engaging any lawyer or any service provider, your rock wills? I think that yes, of course you can DIY, write a will, no problem. But the thing is, if you're not very familiar with all the legal terms and things like that, then I'll suggest you to still engage a service provider, because a lawyer that specializes in estate planning, not any lawyer. I know that lawyer that specialize in litigation, they might not be very well versed in the ins and outs of estate planning, right? Or even organizations like rock wills and stuff, they have their own legal advisor. They can advise you whether whatever you write in a will is legally binding or not, or legally valid. You can't write something. So perhaps if you are not in this law, not law jargons and stuff, so it's very useful to have someone to say that what you wrote is legal, can be executed. I mean, that's the point, right? Okay, the writing, doing a will by yourself or anyone is just starting point. Because the important thing is when it comes to execution part. So make sure you want to do it yourself. Make sure it's watertight, so there's no potential conflict. Okay, no potential conflict, especially when it comes to things like joint name property. And that is why we still advise clients to go through a proper service provider, supported by a legal advisor or a lawyer specializing in estate planning, to actually write your will. It could be an upfront money that you pay, but in the long run, it's worth it. Now, the thing is, another thing that I want to share with you, a very practical one, because in a will, whatever will that we wrote, you need to appoint an executor, right? An executor meaning that a person that will actually manage the assets, okay? Meaning if you die, if you take your asset, park it under its own name, and it will distribute or pay your debts, pay your taxes, and then the remainder will be paid to your beneficiary. Now these are all administration tasks. The executor is the person who actually does all this, and he's to run around, go to the court, okay, get your death certificate, and also so you'll be running around. Now the thing is, executor is a person who does all this, and there's no obligation for him to get paid. Now it's something like a charity, right? If you want to appoint, okay, a person as an executor, you better be very sure that the person is willing to help you do all those administration of your estate after you die. It's very important. Okay, you appoint a natural person, make sure he's really willing to do this, because if he's not willing to do this and he say he resign, he don't want to do this anymore, and This is very detrimental because the process will be more complicated. It is as good as no will, right? Okay, it's as good as no will because nobody actually manage your asset. So the thing is, if you appoint an executor, and this Kisah Benar true story is that you appoint, let's say, a brother, your brother as an executor, but your brother stay in KL, and you stay in Penang, for example. Now, do you expect that later, when unfortunately you pass away, your brother to run 2 times, always travel to Penang to manage your estate? He has his own life too, right? So this thing you see, it can be practical, okay? Or there's another option to say that you appoint one of your beneficiary to be the executor, because at least you know that he's getting something in the end. Also, it's very practical, right? Appoint your beneficiary, one of your beneficiaries, as the executor or executors. And of course, the other way, okay, the other way to do it is, of course, to appoint a corporation as an executor. In the term, if you do Rock Wills, you just pay additional 120 to appoint Rock Will as an executor, and that simple as that, right? So yes, back to the point, like can you ask a lawyer to actually draft your will? Yes, you might have your in-house lawyer, your family lawyer, but the thing is, if you were to just engage a lawyer to do it, the cost probably will be very expensive. The time cost is very expensive, and make sure the lawyer is specialized in the laws of asset planning, because not all lawyers, they specialize in different things. It's like specialists, they specialize in throat, nose. It's different from people that specialize in women's illness. So the other thing that we'll cover some of the basics of the will. Condition for a valid will: more than 18 years old for the will writer or the testator, of sound mind. And of course, 2 witnesses would need to be present at the signing of the will to testify that the will writer is of the same sound mind, and it could be typewritten, which is recommended, or even handwritten. Now, for Muslim, you can only, if you write a will, you can only distribute 1/3 of your estate according to a will, a wasiat, yeah, they call it. The 2/3 will be it will be not subject to anything that you wrote in a will. It will be subject to farite law. Okay, so just make sure on that. And another thing I want to see highlight is that if there's any changes in your family status in terms of remarriage or divorce, okay, this is the thing that single parents probably will not need to take care of, is that marriage, divorce, or separation. If you already written a will, how would it change things? Now, the thing is, divorce, okay, does not automatically invalidate a will. I repeat, divorce does not automatically invalidate a will. So when a person divorces, they should update their will immediately, right? Okay, although it does not invalidate a will. A divorce will only revoke or cancel any gifts to your former spouse. Now, it also cancels your former spouse appointment as executor, trustee, or guardian in the will, but it will not cancel an appointment of a former spouse as a trustee of the property left on trust for beneficiary that include children of both of you and your spouse. Okay, that is the law. Of course, when there's dispute when it comes to court, then it would be up to a court to decide, because it was apt to the ability of the former spouse to argue before a court that a deceased person did not intend that it will be revoked by the divorce, right? So these are the things. Now, if you remarriage, now this is very important. Remarriage is when you remarry, the will is automatically revoked or cancelled. That's the thing. That's by law, right? The only exception to this rule is if the will is made in contemplation of marriage. If you're planning to marry in the near future, or wish to have a will in contemplation of marriage, you should obtain legal advisor. Approach us or your lawyer for legal advice on this too. And the next is about asset witch hunt. Now, in practical, a lot of people say, hey, if I change any of my assets, I add in asset or I sell asset, do I need to update my will? I say no, you don't need to update your will. But the thing you can do is, any will you should have these residuary clauses to cover. So you might say that all my bank account to my spouse, all my property give to who and who, my children. But on top of that, where you explicitly state your assets to give to who, you also have this residuary clause to cover, in a sense that any asset not explicitly mentioned in the will have to be covered by this residuary clause. In the residuary clause to say that any asset not explicitly mentioned in the will be distributed to who and who. So that is one might put in this residuary clause, very important. Now, another thing is about asset witch hunt. Now, asset witch hunt, you say that, hey, how my list of assets by the time I write a will and by the time when someone is, or when the will went to execute, when someone dies already, there might be a difference in the list of assets. I say that this no worry on that, because a will is a will, it just lists all your assets. If at the time when the will is being executed, there's another round of what we call an asset witch hunt, meaning that there's still another exercise where the executor need to list all your assets under a will, all the assets that you have, and you have to tally it with a will. Let's say you have A, B, C, D, E in your will. Yes, you have A, B, C, D, E, but after that you have asset X, Y, Z, which is not mentioned in the will. So this asset X, Y, Z would be distributed according to the residuary clauses. Now we see how all this ties together, right? And again, people will ask, how about my overseas asset? If you write a will in Malaysia, this is practical, yeah? How about overseas asset? Now in practical, if you want to use the same will to actually distribute overseas asset, now there will be quite a relatively high cost involved. From what is told to me by our firm panel lawyer, is that this will, you go to the court, okay, the court of that country, you go get a probate, and you need to reseal that again. So that will cost quite amount of money. So a best thing, if you have asset overseas, sometimes we do advise client, if you have a lot of substantial asset overseas, it's better for you to actually write a will in that country. Okay, a will to cover asset in that particular country. That will be more cost efficient. Now this is the practical part of it. Now, of course, the other thing is about the witness. Now, again, a very practical thing. They say that, two witnesses that everyone knows. Witness cannot be a beneficiary. Okay, if not, they will be still valid as a witness, but they will not be entitled for any asset you give to them. So that's very important. And this witness, a lot of people do not know that the witness have to be contactable later when the will executes to prove the will. I mean, a witness is not just like any document you can ask any Tom, Dick, and Harry to sign as a witness, because this witness, 20, 30 years down the road, this witness that signed your will need to be contactable at that point of time, okay, to prove the will. How to prove the will, we'll cover that a bit later in episode 2. But you see, when you do a will, let's say with anyone that offer you to do a will, make sure you do not, you know your two witnesses. If they migrate or what, you make sure you know of their whereabouts, at least when they die before you, when they migrate, yeah. If not, there will be complication if both of your witnesses are no longer locatable. That will actually delay the execution of the will. Again, we'll cover that a bit later, but this is a practical case. So again, some people write a will with some organization whereby they just have a witness as company A, staff A and B, right? Which people that you don't know. Now later, when you want to execute the will, you need these two people who sign as a witness to testify for the will. Now this will be, there's a downfall here, is because if you go back to company A, the staff that sign your will, they might not be there anymore, right? First, you don't know them. Second, you cannot be locatable, and even the company don't know where they went. Maybe they migrate, maybe they die, they don't know. So this will be a complication when it comes to the will. We will cover more that during the probate, the execution and administration part. Now, practically for a will retention, okay, normally you will keep one copy of your will. The service provider, people like Rockville or even your lawyer, they will keep one copy, and this will be the copy that is used for probate, which we'll cover later. And if you appoint any natural person as an executor, it's better that you give them a copy too. Now with that, I'll end my first episode of Will and Trust Asset Planning here. Next, we'll go to probate and administration. I've been talking for 20 minutes already. I hope you have been feeling this is very useful for you when it comes to estate planning. I'll see you in the next episode. This is CF Lieu from howtofinancemoney.com. I wish you a great day.